Hello, neighbor. I'm Robert Burns, and welcome once again to another edition of Sound Off Louisiana. And today I'm going to give you a quick little rundown of what all took place in Judge Don Johnson's courtroom. And let me first of all say how thankful I am for the many words of encouragement, many of you who chose to make public comments on the most recent Sound Off Louisiana post, that being entailing the differences in a treatment that apparently will take place for LSPC, Louisiana State Police Commission member Sabrina Richardson, versus that of Calvin Braxton some years back. I've gotten many other individual words of encouragement, so thank everyone for their encouraging words as we went forward with today's court hearing before Judge Don Johnson. And basically, what transpired at that court hearing, I began off and I stated that it's really very simple, Your Honor. I am looking for another set of eyes to look at these documents. As has been stated in the pleadings, about 175 pages regarding the personnel file of Trooper Scott Lopez. Now, we have extensively reported on Trooper Lopez and the complaints from Billy Broussard entailing Trooper Lopez. And as I said in the pleadings, approximately 135, 137 pages were fully redacted. And I said, but Your Honor, what I particularly want to draw focus on is these letters of counseling/warning. I said, I would be thrilled to get any other documents that this court may deem that the public is worthy to see. But I want to pay extreme focus on those letters of counseling/warning. And I said, and the reason for that is very simple. The only provision by which they have said they have denied providing those letters of counseling/warning to us, knowing that we would reveal them to the public as part of our sound off features, is that there is an LSPC rule, specifically Rule 12.9, that say that these documents are not considered public record. That's all I've been provided with as to why I'm being denied. And I said, Your Honor, and I said, no, I want to make this clear. I'm not being flippant in what I'm about to say. And I could tell then the judge focused in. I said, I'm saying this in all sincerity, and I mean what I'm about to say. And I said, from Louisiana State Police's vantage point, up at the very top of the chain of command, whatever you want to use the phrase, I said, you have the Louisiana State Police Commission. And then immediately beneath them, you have the United States Supreme Court. And I think that drove the point home. And then I said, and beneath them, you have the U.S. Courts of Appeal, and beneath them, you have the Louisiana Supreme Court, and beneath that, the Louisiana Courts of Appeals, and beneath that, the individual trial courts as the venue we're in now. And then beneath that, in LSP's mind, there are the lowly legislators over there, for whom they have shown remarkable contempt, as we have seen lately, especially regarding former Colonel Reeves's journal. And I said that, if they wanted to exempt these records, there was a process for doing that. They could have filed a bill, get it passed into law, and then say, Mr. Burns, pursuant to this statute, these records are exempt and you're not going to get them. That's not what they did. They relied upon an LSPC rule. And I said the LSPC has been well documented as of state police, by state police, and I mean teetotally controlled by state police. We have no say-so whatsoever, we as the public, with regard to the goings-on at the Louisiana State Police Commission. And I did say, Your Honor, I've been videotaping these meetings for 5.5 years now. I know that of which I speak, and they are taking the vantage point that God has spoken in saying that these records are not considered public. I don't believe that's going to cut the mustard. I believe that is insufficient. They don't have the grounds for that, and that they should have, as I said, gone before the legislature, filed a bill, and tried to exempt them that way. I said the reason they didn't go that route is because they figured the bill would not pass, whereas it's a piece of cake to get something approved by the State Police Commission. The counter counsel, and Mr. Farrell was not there. He had a substitute. His first name is Greg. Forgive me, I don't recall his last name right now. Very fine, very nice gentleman. And he said, well, Your Honor, I did not come to prepared to argue about these letters of counseling or warning. He said, and in fact, I don't have them. They've not been provided. And so, and yet he had previously acknowledged that he has viewed all of the redacted documents that I have been denied. And so I said, well, Your Honor, I don't see how they could have not supplied the letters of counseling warning, because they have said, I made the request, as has been noted, for his disciplinary file only after there was such massive redacting in the personnel file. And it was Ms. Holland who sent me a follow-up letter about 9 days after Captain Manali said that, well, he has no disciplinary file, but there are current administrative proceedings pending. And so Ms. Holland sends me a letter transmitted by email about 9 days later and says, well, he does have 2 letters of counseling / warning, but pursuant to this LSPC rule, they are not considered discipline. So I said, if those letters are not in the redacted documents, which would mean they're not in his personnel file, and is that an indication that they are in his disciplinary file, even though they're not considered discipline? I said, oh, because the only other alternative is they withheld the documents, even from the redacted documents. If Mr. Gregg, that's his first name, just going to be informal, if Mr. Gregg is stating before this honorable court that he doesn't have the documents, and yet he has all of the pages that were redacted from me, well, then there can only be one logical conclusion, and that is that they withheld the documents, because the only other possibility is that, well, we have a third category where we file documents, basically called Never Never Land. And so, Your Honor, the judge asked for us to succinctly state what relief we are seeking, and I said, for mine, it's very simple. I am wanting to have these documents examined in camera, and it will be up to this court to determine which documents, if any, are deemed to be worthy of being made public. And I said, but I want to stress, I am specifically laser focused on these letters of counseling warning. And the reason for that is, as I put in the pleadings, I have had troopers tell me that that is a way that if you're in the clique, you can avoid discipline by getting one of these letters of counseling / warning, because they are not considered discipline. And, you know, one advantage that I had of going to all of these state police commission meetings and getting the terminology down is that I know the distinction, because the words letters of reprimand were being thrown around loosely in the court, both by Judge Johnson and by Mr. Gregg. And I had raised my hand, and, you know, I can't interrupt, of course, but I said, I want to make this clear. These are not letters of reprimand. If they were letters of reprimand, that is a disciplinary action, and they would not have been able to withhold them from me. These are letters of counseling / warning that do not pertain to any existing administrative investigation. It's a simple matter, Your Honor, of this court weighing whether the public's right to know regarding these letters of counseling / warning outweigh his right to privacy. But also this business of an LSPC rule being used to deny public records, I don't believe is going to cut the mustard. And I believe there's a reason that they were completely silent in their 3.5, 4-page opposition memorandum. They don't even discuss the letters of counseling / warning. And I said, and I think the reason for that, Your Honor, is very simple. They know that's where they're most vulnerable. And so they may remain silent on the matter, and I guess they hoped that I would not bring it up. And I said, Your Honor, over half of my pleadings were dedicated to these letters of counseling and warning. So Mr. Gregg's statement that, well, he didn't come prepared, nor did they see a need to address that in the opposition memorandum, I said, that can't be laid at my feet. I did not go over there and instruct them what to put in their opposition memorandum and what not to. The reality is that my pleadings were heavily emphasized, these letters of counseling / warning. So it's out of my control that they made a conscious decision not to address them. So basically, here's what the judge ended up. Oh, and I do want to point out one other thing. I was told I needed to make this point, and so I did. I was told that, and I have not gone in, I've done a little bit of research on it, but not thoroughly. I was told that that LSPC rule was never published in the Louisiana Registry and properly promulgated, thus rendering it unenforceable. And I did bring that out to the judge. I said, there is that potential. I'll have to delve into it more. I said, but Your Honor, I think that's not going to carry the weight at the end of the day. For the argument I'm making is that even if LSP dotted every I and crossed every T, it doesn't carry the weight that is required to deny me the public records request. The LSPC, even though the mentality is that it sits above the United States Supreme Court and that when that body speaks, it is equivalent to God having given a mandate. That's just not the case. They don't want to dignify the legislature by going over there and doing it the proper way, which would have been to have gotten a statute to specifically exempt these letters of counseling / warning. And, I said, Your Honor, it's no secret that we've had an awful lot of problematic activity with regard to state troopers in the last few years. There's no need belaboring this court's time with them because they're very high profile and there's no need to rehash them. But I think that the public's right to know has been downplayed to an extent that that pendulum needs to swing. And so what I am seeking of this court is to review those documents in camera, particularly the letters of counseling / warning, and it's my hope that at least the letters of counseling and warning will ultimately deem to be made public. So the judge said that here's what's going to happen. We're going to have another court hearing on June the 20th. That's June the 20th. That's 4 weeks from today. And prior to that time, state police is responsible for submitting all of the redacted documents under seal. And he said, Judge Johnson made it clear that whether they were in these 137, whatever the case, of redacted documents presently or not, the letters of counseling / warning need to be included in what gets filed under seal. And he said that LSP would be responsible for drafting the specification in the filing that these were to be filed under seal, and then he being Judge Johnson will examine these documents in camera for his eyes only, which is exactly what I had asked for. And then we will have another hearing on this matter on June the 20th. At that time, each of us will have been responsible for submitting our briefs at least 8 days prior to that meeting, which would be June the 12th. And in my case, I am to state the brief for why I believe the letters of counseling and warning should be made public. And that's not going to be a difficult job for me because I've largely already done that in my pleadings and I've just reiterated it to you, and I will be making those same arguments. I don't know what the contents of the memorandum from state police is going to say as to why they believe that the letters of counseling / warning should not be made public. And I stand by the fact that if you wanted that to be the case, you should have gone to the legislature and gotten a specific statute to exempt that. And I think the one court case that I cited in my pleadings makes that clear, that you need to reference a specific statute. They can't do that in this situation because they're relying strictly on an LSPC rule, which I believe to be inadequate. Now, Judge Johnson did make it clear that if he renders documents to be appropriate to be released to the public, his decision will be automatically sent up the chain to the First Circuit Court of Appeals, because he said what he did not want to have happen, and I can understand this, what he did not want to have happen is him make a ruling that certain documents are free to be disclosed to the public, and then they be disclosed, and then state police opt to appeal, or and it'd be too late. The documents are already out there, and so That's basically in a nutshell where everything is. If you ask me to rate it on a scale of 1 to 10 as far as how satisfied I would be with today's court hearing, I would have to say a 10. Simply because I got what I'm asking for. That's all I've ever asked for, is for the court to review the documents. And if Judge Johnson says that every single one of these documents needs to remain redacted, then that'll be that. I did point out to Judge Johnson that, in sharp contrast, over in Texas, when you get a public records request that is denied to this degree, it is automatically submitted to Texas Attorney General Bill Paxton. And I am aware of situations, I know them firsthand, where the Attorney General's office in Texas has said, no, you will be releasing these. And I said, unfortunately, Your Honor, and I know the court system in 19 JDC is bogged down, I know that. And I said, but unfortunately, Your Honor, you're all I have. You're the only mechanism I have to get another set of eyes looking at this to make the determination. So that's the relief I'm seeking, is for this court to look at the documents and make the determination, and then we'll go from there. I realize this had to be a patient process, but I've been covering state police very actively now for 5.5 years, and I think I've had pretty decent patience in that regard, and I will plan to continue that on as we embark on the future court hearing and I guess First Circuit Court of Appeals ultimate rendering. And I guess the one thing that may evolve here is this may make case law with regard to whether these letters of counseling / warning are going to be considered public record. And I think they need to be, because if I am sent guidance by any retired troopers or active troopers that, hey, you might want to make public records requests about so-and-so's letter of counseling because so-and-so over here got a full-blown suspension for the same identical act, you can take it to the bank. I'm going to make the public records request to point it out, because I believe that's the only way we can try to hopefully get some kind of level of fairness of treatment amongst troopers, irrespective of who the colonel may be, and certainly fairness to the public, because some of the things that have transpired, and I don't have to say alleged things that have transpired, because nobody disputes at this point that they have, they are inexcusable, and we have to have some kind of way to find a way to curtail this type of activity in state police. So with that is the update on where everything stands in Robert Burns versus Colonel Lamar Davis in his capacity as the custodian of records for Louisiana State Police. And thank you so much for your dedication, and once again, thank you to everyone who gave the words of encouragement, and we will certainly keep you updated as further developments unfold. And if you see it, don't get used to this. This was my courtroom attire, but that's the only reason you're seeing me like this today. So thank you once again, and thanks for everyone's dedication to the Sound Off Louisiana blog. We'll be updating you again as further developments unfold. Thank you.